Good afternoon. May it please this honorable court, Dion Webster Cox appearing on behalf of Mr. Harris. How are you, Your Honor?
Buckle up, because this courtroom session is a powder keg waiting to explode. This is the now viral case involving Mr. Harris, who appeared in court while driving on a suspended license, and then went on to accuse the system of failing him. From claims of misinformation to public blame games, this case is a ticking legal time bomb. Judge Simpson is not having any of it. He's calm, collected, but visibly fired up. You can feel the weight of years of legal discipline behind his words. He's not just addressing a case, he's about to issue a public reckoning. The stakes, Mr. Harris's freedom, his license, and the court's integrity. In the next few minutes, you'll see finger pointing turn into truth bombing, and a judge who will not let misinformation stand. You'll see how failing to own up and going viral can backfire in the worst possible way. This is courtroom drama at its absolute peak. Stay sharp.
We will see.
We're good. We're good.
Mr. Brown, or somebody from the PD's office, because I did not get a substitution. I got an appearance.
Oh, I've got a substitution right here.
Signed off on?
It is.
All right, then I don't need to address. The public defender's motion to withdraw. I'll consider that withdrawn given the substitution. I do have an appearance and I will sign off on the substitution.
Thank you.
Thank you. All right, what are we doing today?
So, Your Honor, there's several options that my client.
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say.
Okay.
Because I think the record, given particularly some of Mr. Harris's comments with reference to this court potentially acting what, at least as I'm to understand, is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing.
Whoa, did you catch that? Judge Simpson just confirmed that the information brought to light by Mr. Harris, the very thing he was screaming about in the media, was actually correct. That's not something you expect to hear often. A court essentially validating that it acted on bad information? That's rare and heavy. But the real kicker here is how the judge handles it with full transparency. He's not dodging it, he's owning it publicly on the record. That is a hallmark of judicial integrity. And while he validates that the info was wrong, he's also building a case that the blame doesn't end where Mr. Harris wants it to. In fact, things are about to take a sharp turn. Question for you. If a judge admits faulty information played a role, should that automatically give the defendant a free pass? Or does intent still matter? Let us know what you think in the comments.
And I think it needs to be stated, I've been asked for comments. I have refrained from comments, as my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before.
Absolutely.
I know it is not coming from you, but you also know how I am.
I do.
And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it, and did. But when I'm not wrong, and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license, let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever.
Hold up. Stop right there. Judge Simpson just dropped a bombshell. Mr. Harris has never had a driver's license. Not in Michigan. Not in any of the 50 states or commonwealths. Let that sink in. And yet, this man managed to get caught driving on Zoom during a court hearing, all while under the impression that he was the victim of systemic failure. The truth? He was never legally in the driver's seat, literally or metaphorically. This moment shatters the entire defense. There's no license to suspend, reinstate, or defend. Just the cold, hard truth that this isn't a bureaucratic mishap. It's a long-term personal neglect turned viral embarrassment. It's at this point that the judge starts turning up the heat, not just for clarity, but for accountability. And Mr. Harris? He's losing credibility by the second.
And has never had a license in the other 49 states and commonwealths that form up this great union. He has never had a license. In point of fact, when they suspended his license, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, but that wasn't at all said. But it doesn't matter because he didn't have a license ever. There is also then, and I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was, his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Therefore, that friend of the court was under no obligation to send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's then an indication from that because that wasn't sent, there was a direct attack on Michigan's Department of Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or the latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended.
This is where everything could have ended cleanly. Mr. Harris finally paid his reinstatement fee. The friend of the court sent the right paperwork. The Secretary of State did their job. His suspension was lifted. Case closed, right? Not quite, because while the paperwork eventually caught up, the damage was already done, and the judge makes it clear. All of this could have been avoided if Mr. Harris had simply acted sooner. The problem wasn't the system dragging its feet. It was Harris not walking in the door. You can almost hear Judge Simpson trying to suppress his frustration as he outlines how many agencies followed protocol, yet somehow ended up being blamed. If there's ever been a clearer example of how perception twists reality in the courtroom, this is it.
And then your client did what he needed to do with reference to the Secretary of State and paid a read. Okay. Just a second, Mr. Schiller. I'm going to let everybody respond because
Thank you.
I am not done yet.
Okay.
All right.
You're covering a lot of the points for me. Thank you, Your Honor.
And so that came down to that. So the information at the time that I had, that Pittsfield Department of Public Safety had, was all correct at the time of both Pittsfield stop as well as the May 15th day. It was all correct. There was no error by anybody. It was a failure on the part of Mr. Harris to do certain things.
Here comes the accountability hammer. Judge Simpson finally lays it bare. Mr. Harris failed to act, and no one else is at fault. This is a classic moment where the court takes the time to educate, not just adjudicate. Simpson isn't just passing judgment, he's walking the public through the exact steps that went wrong. It's rare to see such a detailed dissection of procedural failure. And let's not ignore the tone shift. The judge moves from validation to admonition in under 30 seconds. This is where the courtroom stops being a place of confusion and becomes a stage for brutal clarity. Here's something to think about. Should courts be responsible for holding everyone's hand through these processes? Or is it up to the individual to stay informed? Drop your thoughts below.
Now, I grant you that sometimes that can be a complicated process, but it was certainly not anybody's fault that that didn't happen other than that wasn't paid. Now, here's the other thing, and I'm like maybe in church where I say I'm about finished now, but the other part of this is this stop was in October. Most of the cases that we've heard just in this last afternoon are driving while license suspended cases. That's part of my Wednesday afternoon. We go through great pains to try to get people their licenses back, which is really how it should happen. Between October and because I don't live under a rock, I actually watch things. You look very nice on TV.
Thank you.
You're welcome. There was something that was said that was very disturbing to me. And I'm just going to let you know because I believe in being fair with everybody. The question was asked along the lines between October of 2023 and the point in time of the May 15th hearing. Was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me, so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. And being involved into the accident, that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there, and I'm going to presume, because my knowledge of counsel, defense counsel is, I know you don't misrepresent anything.
Right.
You never do.
Right.
That's not true.
Okay.
He purposely stated that he could not get to the Secretary of State, which for the way we handle things in this court would have placed him in a whole different category. We would have tried to find a way, let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 28th, 23.
23rd.
2023.
I know I was laid up from my
You
accident.
were at the Secretary of State's office. And you were at the Secretary of State's office because you redid and got your new Michigan ID.
Boom. The timeline just broke down completely. Judge Simpson caught Mr. Harris in a major contradiction. He claimed he was bedridden and couldn't get to the Secretary of State's office. But on December 28th, he was literally there in person, getting a Michigan ID. This is the kind of moment that tips the scales hard in any courtroom. What makes it even more damning, it wasn't the prosecutor who revealed it. It was the judge who personally verified it. This isn't speculation. It's documented fact. This isn't just a contradiction. It's a credibility collapse. And when you're trying to convince the court that you're a victim of broken systems, the last thing you want is a factual contradiction delivered with timestamps.
I have the date. That's the date you did it. December 28th, 2023. You did. And so that you also know, and in all fairness to counsel, because I don't know if counsel knows this or not, the way I know that he's never had a license is because May 3rd, 1990, he was 19 at the time.
And now, the pivotal moment. Officers say he refused to step away. Pay attention, because whether that counts as obstruction becomes the heart of the fight.
May 3rd, 1999, he applied for his first Michigan ID. Counsel knows, so I do, you cannot have both. You either have an ID or you have a license, one of the two. He has religiously every year gotten a new ID. And so he knows that he doesn't have a license. And quite frankly, I just wish he would have said that at the beginning.
This is the heartbreak moment. The judge's voice shifts from frustration to disappointment. It's clear that all of this, the viral spectacle, the courtroom drama, the news reports, could have been avoided if Mr. Harris had just told the truth from the start. There's a lesson here that echoes far beyond this case. Owning your mistake isn't just about humility, it's about protecting your future. Had Mr. Harris been honest from day one, this judge, who clearly values rehabilitation, might have helped guide him out of it. Instead, we're left with a courtroom cleaning up the mess of public misdirection. And in that cleanup, no one walks away spotless.
And all of this hoopla could have been just put all aside. And we all go through the process as we do with all of the people coming here to try to get him his license back. But his falsehoods, misstatements are not going to fare him well in this court. I'm done for now. I'm sure I will have something else to say. Whichever one of you would like to speak first, you may.
I'll wait to go last.
Yes, I spent yesterday at the Pittsfield Township Police Department with Officer Monaster performing the traffic stop in this case. I also noticed the December 28, 2023 date, and I know the significance of that, and the court just went through that painstakingly, and I thank you for that. In addition, at the traffic stop, when I was at the police department yesterday, we watched the body cam video. At least twice during this traffic stop, he acknowledged to the officer that he did not have a valid license. Quote unquote, quote, actually, I don't have a valid license, close quote. The question was, are you a valid driver? Quote, I am not, close quote. So, you know what, this is all this hoopla and the circus atmosphere is, in my opinion, is an affront to the justice system.
The prosecutor finally unleashes, and it's scathing. He calls the situation a circus, an affront to the justice system, and makes it crystal clear the real problem isn't just the license, it's the performance around it. This is a powerful moment that reminds us how courtroom antics can cheapen the very system meant to protect justice. But notice what he doesn't say. There's no grandstanding, no political spin, just raw frustration from someone who's seen too many of these performances spin out of control. This isn't about making an example, it's about restoring credibility. And right now, Harris is running out of rope.
I mean, I've been a prosecutor for more than 30 years, and to see this kind of hoopla around a driving while licensed suspended case is ridiculous. And it wasn't caused by this court. It wasn't caused by the Pittsfield Township Police Department. It was caused by the extrajudicial statements made outside this courtroom.
Thank you.
Okay, so
Go ahead, counsel.
thank you, Your Honor. Thank you very much. Well, first thing I'd like to say is, very first thing is we're here and that we all saw this video. I wasn't in court. I wasn't even on YouTube watching the court today, right? I saw it because someone saw it and decided to post it. I can assure you that that was not Mr. I don't think he has the capacity to be able to post it like that on YouTube or Instagram. So that was not him. And it happened to take off and go viral. So he had what we saw was him saying he was driving, which he should not have been driving, right? We're told not to drive on Zoom while doing that. So that's how this came to the attention, because the court, I saw you. He said, I can't believe this. Is he driving? And we all said that. Everyone who saw that video asked the same question. And that it became a joke. It became a complete joke.
This is the defense's most human moment. Mr. Harris's attorney isn't denying the facts. He's focusing on the reaction. He points out how even the judge himself was stunned to see a defendant driving during a Zoom court session. It's absurd, it's viral, and it's why this became a spectacle in the first place. But what's key here is that the defense is trying to pivot from embarrassment to empathy. They're not fighting the narrative, they're steering it. Can this work? Maybe, but only if they can regain the court's trust, and so far that's a steep hill to climb.
Now, with respect to what we want to do, and I cannot say anything is with respect to what my client has said, but when we talk about the hoopla, my client didn't start the hoopla. Perhaps he's made some comments, but he didn't start the hoopla whatsoever. That was someone that was outside of his control as to how it went viral. He had no control over that, and that I'm going to stand on that. He did not send it out to Instagram. He didn't send it out to wherever. He didn't do that part. So with respect to, did he have I don't want to try this case today at all, but what I want to do is focus on what's good. Now, what was good? That day in October, this officer here, that could have gone a whole other direction. And I'm so happy that you were so kind and courteous to my client. Thank you, officer. Thank you so much, because it could have gone another direction. We are here right now. My client has an appointment to go to the Secretary of State for his permit. He's working on that. I want to focus on how do we correct this and cure this? How do we go forward with this situation? Whatever, he was not under oath under any of the things that he said. So we're not talking about any type of perjury going on. Very true, right?
True.
So with that being the case, let's move forward with this. He is here. This is what I'd like. Because
Counsel, let me just.
yes,
I would like to move forward too
Yes.
on this case. We handle these cases all the time. But I will tell you, as you know, having appeared before me, the one thing I don't like is when people don't take responsibility for what they've done. When they take responsibility for it, we will use whatever we can to try to get you to another spot, because it doesn't behoove any of us for you to be in that spot. One other thing that I will say, when you say it wasn't started by him, oh, it certainly was. It certainly was when he made his first statement to WXYZ about blaming people for this happening. And he shouldn't have done it, because when you look at the whole thing, the person that needed to be blamed, and we can go back to a lot of other points, but I'm not here to embarrass it, but the person that needed to be blamed is the person that he was staring at in the mirror.
Mike, drop. This line cuts deeper than any ruling. It's a personal mirror held up in court. Judge Simpson doesn't just call out the lies, he calls out the deflection. There's no hiding anymore. Not behind agencies, not behind the media, not behind sympathy. Just a man, his decisions, and the consequences. This is where the courtroom becomes a life lesson. If you can't take responsibility, you can't take control. The judge is practically begging Mr. Harris and everyone watching to learn from this. And honestly, So should we.
He didn't do what he should have done. And that's okay. The majority of people that come here on a licensing didn't do what they were supposed to do. That's like a given. They don't go about blaming anybody. They just say, Your Honor, I didn't pay the ticket. Your Honor, I just didn't do it. I just didn't have the time to do it. I just didn't take whatever.
Right.
Just own it. Once you own it, then it becomes a whole lot easier just to move forward. Okay, I'm sorry. I interrupted you and I said I wouldn't, but
Thank you. I understand.
my court.
I
No, go
no,
ahead.
I know who you are, and I respect that. So, and where I am is where I've always been, because I can assure you that when he did speak to WXYZ that day, I wasn't representing him. I was representing him yesterday, right? And you would heard my message. It said, what steps are to correct this? And that's what I'm about, Your Honor. How do we correct this, right? I understand the entire process. I have not gone into detail, but I will take the word of the court and of Mr. Stiller here, brother counsel, and about the background and the history of it. But how do we go forward? And that's why I'm here to sort of minimize. You okay? And he did get into an accident.
He can sit down. He can sit down.
Please, Your Honor. Right behind. Oh, well, hold on. Okay. And now that's real. That's a real injury.
I have no comment.
Okay. So what we're looking for, because there are some options here, my client has indicated to me and would like me to indicate to the court that he is in the process of procuring his license. Oh, hopefully that privilege will be available to him, but he does have, as you stated earlier, and I have the receipts, he did pay the reinstatement fee. Those fees are paid. Anything that was out in the previous court, those fees have been paid, and I've been presented with those receipts. In addition, on tomorrow, he's got his permit test coming up, and then after that, because he's an adult, he's working on it so that he can take advantage of the offers that are available, because as you say, this court does want to help. Absolutely. And with that, because my client was in an accident, and I haven't seen the medical records, but because of some of the things it could be, I don't know. But sometimes our memories get a little foggy. Now, am I going back to 1999? No, I'm not. But I'm just saying that I'm saying from this day forward, he is working diligently to take the steps necessary to get this driver's license so he can take advantage of the generous offer. Thank you.
Yes, ma'am.
Yes.
Yes,
I
Mr.
hate to say this, Your Honor, one additional thing. I think Fletcher Cox and I need to approach the bench. It may involve Mr. Allen.
Who's Mr.
I
Allen?
know, because I know what it is.
Okay, thank you.
Well, who's Mr. Allen?
That's my bailiff.
Oh,
I will give out whatever date I can.
okay.
Counsel, you probably didn't know this, and I wasn't sure where the prosecutor was going to bring. He's got a warrant.
No, I did not know.
Yes, he has a warrant for his arrest.
Plot twist incoming. Just when you think it's wrapping up, Judge Simpson reveals that Mr. Harris has an active bench warrant out of another jurisdiction for the same offense, driving with a suspended license. This isn't just bad luck, it's a pattern, and the judge clearly knows it. You can see how careful he is, making sure the warrant is still valid, checking if pickup is likely, and even offering to set a nominal bond to avoid unnecessary detainment. That's compassion, wrapped in accountability, but it also shatters any remaining illusion that Mr. Harris was just unlucky. This isn't a one-time error. It's years of neglect coming home to roost.
A bench warrant out of
Allen Park.
Allen Park. Mr. Allen.
24th District Court.
Okay.
The shocking thing about it, for a driving while license suspended, that he didn't take care of.
Okay. Well, like I said, he
So-
wants to handle.
So
He's
what it
dedicated.
is that and it's a valid warrant. I happen to be within their radius of pickup. Now, having said that, I don't know if they will pick him up.
Okay.
I will say that what should have happened, I'm not going to go through and try to figure out whether it did happen. But when he was arrested, when he turned himself in on my revocation of bond, upon being released, he should have been apprised, warned, and released to go take care of it. I don't know whether he was. I really don't care whether he was or not. All I know is that was back at mid-May, and it hasn't been taken care of. And it's still valid. I was hoping maybe that somebody was going to try and take care of it, because I'm sure if you had known, they would have been done. So much so that part of my delay in getting out of here was to make sure that it was valid. I had my staff run him right before I came out, so that if it hadn't gotten taken care of and in, then fine, we were okay and I didn't need to deal with it.
Right.
But it's still there.
Okay.
So will July 17th work as a new date for you? Come back, because as I understand it, he is right now not licensed. So if he goes in on Thursday, gets his permit, he's got to drive for at least 30 days. Apparently he knows how to do that part. Sorry, that was Adam. I'm sorry, I didn't need to say that, but he knows how to do that part, but then he's got to go back, take the test.
Right.
And then he can do that. He may be able to accomplish it in that time, that 45-day period. If not,
Despite everything, the lies, the drama, the warrants, the court still offers a path forward. Judge Simpson sets a new date, August 7th. He wants Mr. Harris to get his permit, take the test, and earn that license. This isn't about punishment, it's about progress. But the tone is unmistakable. This is the last chance. What makes this so powerful is the underlying message. The system isn't your enemy if you engage with it honestly. And Judge Simpson, he's giving Mr. Harris one final shot to prove he's capable of change. Will he take it? Or will we be back here again, next time, with fewer options?
I mean, counsel, I just want him to have a license.
We all want the same thing. One moment. So the 17th, it may not be me, it'll be another attorney from my office who can.
Well, I don't
I'm
want
in
that.
trial.
I don't want that.
You want me?
Yeah,
Okay.
I know. You'll never hear me say that. but I don't want to go through this whole, you understand it.
Right. No, I get it. So I started trial on the 15th and
What's my date after the 17th?
August 7th.
What about August 7th? We can just put it out and then he can do what he's going to do or not do what he's going to do, but he should be able to.
August 7th at 1:00, or would it be at 9 a.m.?
I will set it at 9. We will send it in right now that we have your appearance. So you'll get a direct invite from us as to what time slot he's.
Okay. And then I just need one moment to talk to my client. You want to
Yes.
tell me something? Okay. August 7th at 9 a.m.
At 9 a.m. I'm going to take him into custody on the warrant. The only question that I have, and the way I look at the warrant, the bond looks like $500.
Okay.
Two things. First, I don't know whether or not they'll come get him. If
Right.
they don't come and get him, we'll release him. We're not going to hold him. If they are coming to get him and he's going to be held, the only question I would have for you, counsel, is do you want me to set a nominal bond on this so that he gets credit, or do nothing and not worry about it? I'll leave that up to you.
Okay. That will be, but absolutely, I want him to be able to get full credit for anything that is necessary.
So let's do it this way. If he's not, so I'm going to take him in. If for whatever reason he's not released tomorrow, call my office, and with the agreement, I will set a nominal bond
Okay.
on it rather than do it right now. So he has to deal with two things. So that you're also clear. Part of the reason I'm also doing this is because I think he was warned and released, didn't take care of it. And secondly, this has been out there for 9 years.
Well, I did not know about it, Your Honor. Okay.
Counsel, there is not a doubt in my mind that that's true. No, you did not. I go to the bank on that one in a minute, because I know you would have taken care of it.
Yes.
All right.
It's going to be taken care of today. His wife is here and
Okay.
it will be taken care of. So I will absolutely call your office tomorrow to see
And
what
that's
is,
where the gavel
call the court to
lands.
see the
After all
status
the
of it.
drama, finger
Cool, we're
pointing,
gonna take
and
care of
viral
this.
confusion,
Okay, that's
Judge
what we're gonna do.
Simpson
We'll see
does
you in
what
August.
good judges
Okay.
do.
Defendant is
He
remanded on
clarifies
the
the
Allen
record,
charges.
enforces the
Sir,
law,
you can go
and
with my
still
bail.
extends a hand for rehabilitation. Mr. Harris is taken into custody on the outstanding warrant. But the bigger story is the road he's now being given. August 7th is his deadline to clean this up. This case is a reminder that courts aren't just about rulings, they're about responsibility. Mr. Harris had every chance to avoid this. And while he made it harder for himself, he's still being offered a path forward. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.